This is lesson 35 on community pharmacy practice rules. This lesson is going to be covering pages 196 to 213 in your book. So as you can see, this is a little bit of a longer section. It's more pages in the book. It's going to be more slides. It's going to be a slightly longer lesson, but I just didn't want to try to divide up the community pharmacy rules into more than one lesson. So bear with me on a little bit longer lesson, and we'll get through this together. So you can see on page 196, we're going to start out talking about the Prescription Department Manager, or PDM. We've talked about this position before when we're talking about personnel. This is often referred to as a pharmacist in charge in other states, but Florida uses the term Prescription Department Manager for community pharmacies and requires that each community pharmacy have a licensed pharmacist who is the designated PDM, or Prescription Department Manager. You can see the responsibilities for the PDM are listed there: maintaining records, providing security, and basically ensuring that the pharmacy is complying with all statutes and rules. You generally can't be the PDM of more than one pharmacy at a time. Sometimes the Board of Pharmacy will grant exceptions to that, but that's kind of the general rule you see on the bottom of page 196 and over to page 197. If you change the PDM at your pharmacy, within 10 days you have to notify the Board of Pharmacy of the change in PDM. And this is often something that doesn't get done, and I see people get disciplined for this quite often. It's not a major type of discipline, but something you could avoid. So make sure you always notify the board of a change in Prescription Department Manager. Some additional rules related to community pharmacies. We've got a rule on regulation of daily operating hours, and this says that they want community pharmacies to be open and available to the public. That's the whole idea. So it says if you have a community pharmacy permit, you must be open for at least 20 hours per week. So there's something to keep that in mind if you have a community pharmacy. There's also a section there, number B2 on page 197, about commencement of operations. And what this is about is that they don't want to give pharmacy permits to you if you're not going to actually open up as a pharmacy. So if there's some type of delay and you're not going to be able to open up and commence operations in your pharmacy after you've gotten your pharmacy permit from the board, once you decide you're going to delay your opening and make that decision, you've got to notify the board within 14 days and the reason why you're not going to open your pharmacy. It also requires you to post a sign in the building that says why you're not open yet in your pharmacy. You can read that in number 3 on page 197. And then if you go past 6 months, they want you to provide a written statement to the Board of Pharmacy, because they don't really want to give out permits if your pharmacies aren't going to actually open. So you can read that on page 197 and going over to page 198. There's also a requirement there, number 7, you'll see on top of page 198, that if you're not open 40 hours per week, you must post your daily operating hours. I think most pharmacies post it anyway, even if they are open 40 hours a week, but it's actually required if you're going to be open less than 40 hours per week. Then we got this other rule, 28.109, and it's titled Prescription Department Padlock Close. And the basic thing here is that the board considers that any establishment that has a pharmacy license, this is really more for community pharmacies, but it's really for anyone, it's considered closed when a pharmacist is not on duty. And when a pharmacist is not on duty, they want you to post a sign that says, and it's got to be 2 inches in height, that the prescription department is closed. And this is particularly for pharmacies that are within locations where the actual store may be open, but the pharmacy department is closed. Let's say in a grocery store or in a Target or something like that, where the actual store can be open, but the prescription department is closed. When the prescription department is closed, which is when there's no pharmacist there, this sign has to be posted outside of the pharmacy. We also have a meal break rule under Florida law, which allows a pharmacist to leave the pharmacy for meal breaks not to exceed 30 minutes in length, and under those conditions, the pharmacy department is not considered closed. So that allows technicians to actually stay in the pharmacy and continue to process orders. Of course, nothing can leave the pharmacy until it's been checked by a pharmacist. But again, if that happens, there's a sign that's got to be posted that indicates, when the pharmacist is going to return from their meal break. You see the study tip there on page 199 that, remember, the pharmacist can take up to a 30-minute meal break, but they cannot leave the premises of the facility during this meal break. And during this time, the pharmacy is not considered to be closed while they're on the meal break. Okay, let's talk about generic substitution and substitution of biosimilar products. So this is a topic that generally does show up on the MPJE. I think sometimes younger pharmacists don't realize how controversial generic substitution used to be. It's so common now and so encouraged. I think it's something like 90% of prescriptions that are dispensed are generic, but it didn't always used to be that way. So the rules on this are fairly detailed and complicated, and they vary from state to state. Some states have mandatory substitution. Some states have you can choose to substitute. Every state is different, so just make sure you read a section carefully. What the Florida law says is pharmacists must substitute a generic. Again, there's always an out if the patient refuses it or the physician refuses it, but you must substitute if the drug is on the pharmacy's positive formulary. So substitution is mandatory if something's on a pharmacy's positive formulary. All community pharmacies in Florida are required to have a positive formulary. Now, my guess is most pharmacies probably have all FDA-approved generics on their formulary, but they don't have to. But you're supposed to have an actual positive formulary. There are ways to prohibit substitution, however. And what you'll find with the rules to prohibit substitution is because government is paying for a lot of prescriptions through Medicare and Medicaid programs, and generic prescriptions save the government money, they try to make prohibiting substitution with a generic product difficult. So the way they do that is on a written prescription. Remember, everything's got to be electronic in Florida, but again, there's a lot of exceptions to that. But on a written prescription, the prescriber can prohibit substitution by using what I call the magic words. And the magic words are the words medically necessary, and they got to be in the prescriber's own handwriting on each prescription. So they got to actually write out those words. They can't have a box that they check, or they can't put a stamp with medically necessary. Now, electronically, it's not that difficult to do this anymore, but back when everything was in written prescriptions, they tried to make it as difficult as possible. Because even with verbal prescriptions, they can prohibit it by just expressly indicating that they want the brand name drug dispensed. But as I said, it's not as controversial now, although there are still probably some prescribers out there that don't want generics for certain products that they dispense. So as I mentioned on the top of page 200, you're required to have a positive formulary in your particular pharmacy. There's also a negative formulary in Florida, but the negative formulary is in a rule, and it's mandated by the state. So each pharmacy doesn't have their own negative formulary. There's a statewide negative formulary and a negative formulary is what? A negative formulary are drugs you cannot substitute generic drugs for. And this used to be very controversial as well, because if you're a brand name manufacturer, wouldn't you love to get your product on the negative formulary? I'm sure you would, because then nobody could substitute it, right? So there were lots of maneuvers and things being done by certain brand name drug companies to try to get their products on the negative formulary. And the negative formulary has changed over the years. Now there's not a whole lot of products on the negative formulary, and they're not products that are actually prescribed that often. So but you need to memorize this list because they could still ask you. Because by law in Florida, you cannot substitute the 6 drugs listed on the negative formulary on page 200. Digitoxin, it's not digoxin, it's digitoxin, which I don't think I've ever seen a prescription for. Conjugated estrogens, dicumarol, chlorpromazine, theophylline, which is not used much anymore, and then pancrelipase products. So that's it. Those are the negative formularies. Again, it's a unique Florida law, so I do recommend that you memorize that list. There's also requirements that every pharmacy have a sign about generic substitution with these big block letters you can see on page 201. And they got to be 1 inch in height. Only pharmacy has such specific rules about signs, and they got to be 1 inch or 2 inch, and what font they have to be in. But we have these things, so you have to know them. You also have to provide notification to the patient when of a generic substitution, that a generic substitution has been made, their right to refuse the substitution, and the price difference had you dispensed the brand name drug. That's a required a required notification that you give to the patient. I'm not sure how that's actually done in practice, if it's done in writing or somehow, but that is the requirement in the law on number 6 on page 201. All right, and then we also have now substitution of interchangeable biological products. We mentioned these back in chapter 1 where we were talking about the orange book and the purple book. This is items that are listed in the purple book. This law says that you can only dispense a biological product if it's not only biosimilar but also interchangeable, and you recall what that is. And it's only a few. The note on page 201 tells you there's only a few products that are actually listed as interchangeable biological products. So let's talk about transfers and common database on page 202 and a little bit on page 203 there. So kind of similar to generic substitution, the transfer of a prescription drug from one pharmacy to another used to be a big deal, and you can see I found it mentioned in two different parts of the statute, and actually 2 different rules. One in 27, chapter 27, and one in chapter 28. It's not a big deal anymore. It's all done electronically. But this rule goes through what you have to do if you're going to transfer a prescription. Either manually on the physical prescription. Nobody does it manually anymore, but you can read the rules for that. This can all be done electronically, but you have to make sure you void the prescription in your system, and you record where the prescription is being transferred to. Remember, pharmacists has to do this. It can't be transferred by a pharmacy technician. I guess the main thing here is that you got to make sure that the prescription is canceled or voided in your system once it's been transferred excuse me, out of your pharmacy. And recall on the top of page 203 that DEA only allows transfers of refills on a one-time basis unless the pharmacies share a common database. Interestingly enough, if pharmacies do share a common database, under Florida law, it says that if they're using a common database, then when a prescription is filled from that common database, it's not considered a transfer, as long as each pharmacy can access that common database. And you can see the specific rules for that in the rules that I reference on the top of page 203. So we've already talked about centralized pharmacy fill services, but there are some specific central fill rules that apply to just community pharmacies. And that is that a central fill community pharmacy, remember, can deliver the non-controlled substances directly to the patient, but not controlled substances. So we talked about that one already when we covered central fill. A central fill, when they deliver a prescription directly to the patient, is really not considered that they're the dispensing pharmacy. What it is the originating pharmacy is still the dispensing pharmacy. Remember, their name is on the label of that prescription. It's more like the central fill pharmacy is just delivering the prescription. They filled it, and they're also delivering it on behalf of the originating pharmacy. So you'll see that in number 3, G3 on page 203. Also, if you have a pharmacy that is only a central fill pharmacy, then you can be exempt from the requirements to have an area for patient counseling and all the signs that got to be posted in the community pharmacy. Because if you're a central fill pharmacy, no one's actually coming into the pharmacy. You're just sending the drugs back to the originating pharmacies or sending them directly to patients. So this is the emergency prescription refill rule. On the bottom, starts on the bottom of page 203. Now this law is not the law section of where this is at in the Florida Pharmacy Act. It doesn't say it's specific to community pharmacies, but you'll see in the note there that I put it in this section of the book because really that's the place where this is going to happen. Although I guess it could happen in other practice settings as well. And what this law says is that if you have a patient who's on a prescription, they've been on it for a long time, and you feel like they need a refill of the medication, and you're unable to contact the prescriber to get authorization, or you've tried to contact the prescriber, you can't get an answer, you are authorized to use your professional judgment and dispense a one-time refill of up to a 72-hour supply of the medication. And hopefully by that time you'll be able to get a hold of the prescriber and get authorization for the refill. It also allows a one vial of insulin as well. Now, if there's a governor declared emergency order or a proclamation of a state of an emergency, you can extend it to a 30-day supply. So we see this sometimes if there's a hurricane that's hit part of Florida, there'll be an emergency order issued by the governor's office, and the Board of Pharmacy will let all pharmacies know that they can now issue emergency refills of a 30-day supply. Again, you got to use your professional judgment in these situations. You don't have to do this, but it does give you the flexibility to try to take care of the patient when for some reason you're not able to get the refill authorization. Now, number 3 has some other requirements in there. You do have to create a written order with all the information on the prescription and sign that order. You do have to notify the prescriber sometime afterwards that you did this emergency dispensing. What happens if you notify the prescriber and they tell you they didn't really want their patient to have that medication anymore? Nothing happens. Okay, you used your professional judgment and made a judgment call, and you couldn't get a hold of them to authorize it one way or the other, so nothing should happen in that situation. Now you'll see on the study tip that the Florida law does not restrict this just to non-controlled substances. It also allows it for Schedule 3 through 5 controlled substances. It doesn't allow it for Schedule 2. Why? Come on, you know this. There are no refills of Schedule 2 controlled substances, right? That's one of the big things we focused on. But it does allow for Schedule 3 through 5. Now, you obviously want to be more careful if it's Schedule 3 through 5, particularly if it's a pain medication or whatever. But there might be situations where the patient's well known to you and you just can't get a hold of the doctor. Or it might be something like phenobarbital. That's a real, if you don't get a refill of that, that could be quite serious. And the patient could have a seizure or something like that. So that's why controlled substances are included. I think most states set up their emergency prescriptions rules that way. Now, I will say, and this is me getting like a real lawyer, DEA has never given any state an opinion on whether or not you can do emergency refills. They're kind of silent on it. So for purposes of the MPJE, I think you need to answer the law according to the law in Florida that says that you can do this for Schedule 3 through 5 controlled substances as well. Okay, on the bottom of page 204, we're going to be talking about the over 90 requirements related to patient counseling, DUR, and having a patient profile or patient record. And what you'll see there on the bottom is that this rule requires all pharmacies to have what's called a patient record system or patient record. More often it's called a patient profile, but under the rule it's called a patient record. This is a patient profile that lists all the medications that a patient is currently taking. That allows you to do your drug regimen review and look for any potential drug interactions and so forth. And you'll see On the top of page 205, you must make a reasonable effort to keep this record up to date with all the following information that's listed there: the name of the patient, the age, the gender, all the prescriptions that the patient is taking for the previous 4 years. And number 6 is an interesting one. It says it must include pharmacist comments relevant to the patient's drug therapy. And I got in a study tip there, something that I was able to dig through when I looked at the original OBRA 90 laws. And in the OBRA 90 laws that talk about this and having the pharmacist comments on drug therapy, it also says that the pharmacist comments should allow a reasonable observer to review the comments and understand what happened in the past. So in other words, what happened when you spoke to the patient and provided the counseling, which we're going to talk about in a moment. And I think what that's trying to say there is that this should be considered documentation of the counseling that you do. So it's not clear in the Florida law, but I think if you read the Florida law in conjunction with the federal laws that were passed under OBRA 90, where all these counseling laws came from, I think you can read those together to say that, yes, you do have to document the provision of patient counseling when you actually do provide it. And it kind of makes sense, right? You're supposed to document everything. You should also document patient counseling that you do. In addition, you'll see you have to have known allergies, OTC drugs at the patients. All this has to be included in the patient record, so you can refer to this when you do your patient counseling. The other requirement is on the bottom of page 205 is prospective drug use review. You have to review this patient profile every time you fill a prescription for both new and refill prescriptions, and there's specific things that you're looking for here. And I know the computers help you do this, but this is a pharmacist's responsibility, and that's why if an alert comes up about one of these things, it really requires a pharmacist to make a decision as what to do when you identify one of these things. But what you're looking for is overutilization, underutilization. They're not taking their drug, like they're not coming in for refills or whatever. Therapeutic duplication, drug disease contraindications, drug-drug interactions, incorrect drug dosage or duration of treatment, drug allergies, clinical abuse or misuse. These are all the things that are included as part of your prospective drug use. And prospective means you do it before the patient is actually dispensed the medication. Okay, so turning over to page 206, here's the patient counseling provisions in Florida. So first of all, every community pharmacy must have a private area to allow confidential patient counseling. So a consultation area is required in every pharmacy. And what it says in 3B on page 206 is that with every new or refill prescription, you have to provide a verbal and printed offer to counsel the patient. So it is an offer to counsel the patient in Florida. Some states have mandatory patient counseling. That is not the case in Florida, but you do have to have both verbal and printed offer to counsel patients. There is an exception to the verbal offer if the prescription is being delivered, that you can see there in letter 3C. What you have to counsel the patient on is not mandated. It's up to the professional judgment of the pharmacist, as I think it should be. But they give you some suggestions. It may include the following, and it lists 10 items there on bottom of page 206 to 203. But this is not a must, it's a may. So if the only thing you think you need to tell them is take this with food or something like that, then that's all you need to tell them. You don't have to cover all 10 of these things every time you counsel a patient. And of course, it's not required, letter G on page 207, if the patient refuses counseling. But if they don't refuse it, you do have to at least offer it to the patient. Okay, on page 207, we have a part of the Florida Pharmacy Act, part of the statute, that talks about outpatient dispensing using an automated pharmacy system. This is a law, a pretty recent law that was really expanded the potential use of automated dispensing systems to locations that are not at the pharmacy. And this is really intended for, I think, for those kind of automated pharmacy systems where to allow a patient to pick up a filled prescription at another location. We're going to talk later on about another statute, another rule that allows automated dispensing systems at specific healthcare facilities, such as nursing homes and prisons and other places like that. But this one is a little bit broader, but because it allows a pharmacy to use an automated system at a location outside of the pharmacy. And really the only requirement is, you'll see in under J number 1B, is that it's at an indoor environment at a location that increases patient access to their prescription. So it could be in a medical facility. It could be a place of where products are sold, like a store, or any place where there's limited availability of community pharmacy services. These systems require live, real-time patient communication in order to provide counseling to the patient if necessary. So that's one of the differences between this type of automation versus the ones in the nursing homes, which could use like a regular Pyxis type of machine, because those are in healthcare facilities and the drugs are being administered to the patients by a nurse or other healthcare professional. Those don't require live two-way communication. But these are systems where patients can go directly to the machines to pick up the prescription. So it has to have the availability of a pharmacist for the patient to talk to with these types of systems. You'll notice letter E on page 207, they cannot contain any controlled substances, however. You do have to notify the Board of Pharmacy of where these machines are going to be located, but as I said, the restrictions on the location are just that they be in an indoor environment to increase the patient's access to pharmacy services. When you turn over to page 208, you see there's a very detailed, again, policies and procedures that have to be put into place if you're going to have one of these automated pharmacy systems. It gets into everything about testing the accuracy of the system, training of the people that are going to access and stock and restock the system, how you're going to remove expired drugs, and so forth. So make sure you read through the details of that particular section. In fact, the statute or the law that was passed to authorize this is so detailed that there is no Board of Pharmacy rule on this, because the board felt like we don't have to add anything specific to this, because everything you need to do this is outlined in the law when the law was passed. So you won't find a Board of Pharmacy rule on this. You have to go right to the actual Florida Pharmacy Act to get the requirements for this type of automated pharmacy system. So on page 209, we see a rule here about closing a pharmacy. This is Rule 28.202. Again, this rule doesn't say it's specifically for community pharmacies, but it's talking about what to do with your prescription file. So it's more likely going to happen in a community pharmacy. So that's why I included it in this particular part of the book. So you can't just shut down your pharmacy and not tell anybody that you did that. I can't tell you how many times I've been at a Florida Board of Pharmacy meeting to see pharmacists getting disciplined, or owners of a pharmacy having to action taken against them for just closing a pharmacy and not following the rules on how to do that. So this tells you what you have to do prior to closing the pharmacy, on the day you close the pharmacy, and then things on the next page you have to do after you close the pharmacy within 10 days. And it's just kind of common sense that you have to notify the Board of Pharmacy when you're going to close, and you have to also notify the public where your prescription files are going to be transferred to, so they know where they can go to get their refills of their prescriptions. So kind of common sense stuff. The Board of Pharmacy's website actually gives some additional details that are more specific than the rules, and I kind of included those for you in the bottom of page 209 and over to 210. They want you to notify the board as soon as you know the anticipated closing date and the specific requirements of what that notification has to include over on the top of page 210. And then after you close the pharmacy, no later than 10 days after you close it, you have to return the pharmacy permit back to the pharmacy, confirm that a sign was posted outside of the pharmacy to notify patients where they could go, confirm that all the drugs had been transferred out of the pharmacy, if controlled substances were transferred, where they were transferred to, and that all your DEA registration and any DEA 222 forms you have were all returned to the DEA office. Okay, so finally, a couple other miscellaneous laws and rules that apply in the community pharmacy practice. We've mentioned this one several times already, but remember, that only community pharmacies can dispense Schedule 2 or 3 controlled substances. This was really to stop physician dispensing of those particular products. There are some exceptions, very limited exceptions, I think, for some certified pain management physicians and so forth. There's also a statutory provision about fax prescriptions that's still in the Florida Pharmacy Act. You can take a fax prescription from a patient, but you can't fill the prescription and dispense it until you actually have the original written prescription. Of course, this was put into place before we had the mandatory electronic, but that's still in the law, still in the Florida Pharmacy Act. There is a provision in one of the rules that talks about how pharmacies can deal with unclaimed prescriptions. These are prescriptions that you filled, but the patient never picked them up. You can't, because these prescriptions never left to control of the pharmacy, they were in your will call bin or whatever, they can be placed back into stock. However, you don't want to just like empty the bottle into your stock bottle that you have on the shelf, because it could be a different lot number, it could have different expiration date. So you can reuse that and redispense it for another patient, but the beyond use date you have to put on that would have to be the beyond use date of 1 year from the original date that you actually originally filled the prescription. So there was always the question of, this is, kind of makes sense for drugs that never left your pharmacy that were put into the will call bin, but what about drugs that were sent to be delivered to the patient either through the mail or some other process? Could those, if those came back to the pharmacy as undeliverable, could those also be put back into stock? So that's really a matter of interpretation, and sometimes we get interpretations from the Board of Pharmacy through an official process of something called a declaratory statement. And there is a declaratory statement that the board addressed this particular issue, and they determined that yes, a prescription that was shipped to a patient but not delivered has never been dispensed, and it can be returned to stock. However, the pharmacy has to make a decision and evaluate the drug to make sure it's appropriate or not, and consider the conditions under which the drugs were stored prior to returning them to the pharmacy. So it's kind of a judgment call, but the board decided that could be authorized if the pharmacist feels comfortable doing that. Okay, the next section is a section of the Florida Pharmacy Act that gives pharmacists certain rights related to Medicaid audits or any type of third-party audit by an insurance company. This is a very important thing. I think it's helpful because pharmacists have been having trouble with having money taken back after they dispensed a prescription based on these audits. So it gives pharmacists certain rights for these audits. I'm not sure this fits into the MPJE competencies, but I did have one student complain that I didn't cover this in too much detail, so I went into a lot more detail in this version of the book. So it gives you a right for Medicaid audits as the first part of it on page 211, and it says things like you have the right to 1 week's notice prior to the audit taking place for each audit cycle. It requires for Medicaid that the audit be conducted by a Florida licensed pharmacist. They can't send a pharmacist from another state. Well, I guess Medicaid, if it's a state Medicaid program, they wouldn't do that. But it does have to be a Florida licensed pharmacist that performs the audit. It also gives you, if you turn to page 212, number 7, at least 10 days to produce documentation to address any discrepancy that was found in an audit. And then letter C has protections and rights that you have for audits that are conducted not by Medicaid but by a private health insurers, including any PBMs or other similar entities. This one requires notification at least 7 calendar days before an initial on-site audit. It also does not allow an audit during the first 3 calendar days of a month, I guess because that's when pharmacists are very busy. You'll see number 3 there, it limits the duration period of an audit to the previous 24 months after it limits the audit to a period of 24 months after the date a claim is submitted or adjudicated by the insurance company. So they've got 24 months to conduct an audit after you submit a claim. If it goes beyond 24 months, they cannot go back and audit that particular claim. And you can read through the other protections that were put into the law on the bottom of page 212 and over to 213. Again, I think this is really important stuff in practice. I'm just not sure if it fits into the MPJE competency statements, but you never know. And finally, the last thing in a community pharmacy practice that you might see, and we mentioned this earlier as well, is that there is a statute, and this is in Chapter 499, so it came up when we talked about Chapter 499 on the Food, Drug, and Cosmetic Act, is that pharmacies and other retailers as well may not sell dextromethorphan products to a patient younger than 18 years of age. So keep that in mind. That would be an easy question that you would not want to miss on the MPJE. And actually, I put in the study tip there, there is a competency statement that says restrictions on sales of OTC products. This is a restriction that could apply and fit in that particular competency statement. All right, I know this has been a little bit longer section. I appreciate you sticking with me. I think I have a little bit more questions on the quiz because we covered a lot of material in this one. But go ahead and take the quiz. And this is the end of Lesson 35. We'll pick up with the institutional pharmacies in Lesson 36 on page 213.